Okay, good people. Let's talk about waiving the court. Let's get to it. Let's do another one. Waive for court generally means a defendant in a legal case has chosen to give up a right or privilege, allowing the case to proceed to the next stage without a specific hearing or process. Now, mind you, people, this waive the court, it's not the same as, like for an example, when you go in and you say, I waive the court, or I waive this court. Okay? It's a different process. I mean, it's essentially done the same way, but it has two different meanings. Okay? All right, so let's continue. So, allowing the case to proceed to the next stage without a specific hearing or process. This could involve waiving the right to a preliminary hearing, arraignment, or even a jury trial. Essentially, the defendant is opting out of a step in the legal process, usually to expedite the case or for other strategic reasons. Okay? So when you waive the court, you're essentially saying that you don't need the court to be a part of this. I don't need this court to be a part of this matter. In other words, like for an example, the purpose of a court is when the matter cannot be resolved in the private, and then the matter gets brought into a court because it cannot be resolved in the private. So by waiving the court, what you're saying is, I don't need this court to take care of this. You know what I'm saying? There's other means, methods, avenues that we can use to satisfy the disagreement that's occurring. Next, here's a more detailed breakdown. Waiving a preliminary hearing. In criminal cases, a preliminary hearing is held to determine if there's enough evidence to move forward with a trial. By waiving this, a defendant might be trying to avoid negative publicity, hoping to expedite the case, or potentially waiving to avoid facing witnesses. Waiving arraignment. Arraignment is when a defendant is formally informed of the charges and enters a plea. All right, and we know we don't enter any pleas. All right, we don't understand the charges and we don't enter any pleas. Waiving arraignment means the defendant acknowledges the charges without needing to be present in court, often because they plan to plead guilty or not guilty or to save time. Waiving a jury trial. This means the defendant chooses to have their case heard by a judge, a bench trial instead of a jury trial. Now, people don't remember, it's the stuff that's here, it's these people that are writing out their stuff, so they're always going to write it in a way to whereas you stay within their system or you operate within their system. But obviously, a jury trial is not the only kind of trial that you can have with a jury. You can have a trial by jury, which is more of the common law, organic, constitutional method of doing it, which is a trial by jury or a jury trial. A jury trial is when the judge is running the show, and basically the jury is literally there. They're more there as a token, you know what I'm saying, as a figurehead, if you will, so the judge can end up making a ruling. So the judge is running the court in that regard, and the jury is they're just figureheads. All right, that's a jury trial. A trial by jury is when the jury, you have a jury convene, they have a foreman, and either the jury or the foreman or both are knowledgeable about the law. Okay, and then when they make a decision off of it, the judge has no say in that decision. The judge has no say in that decision. And what they say is final. Okay, that is a trial by jury. Jury trial, it can go either way, but the judge tends to have the final say regarding that. Waiving a right to counsel. Defendants can choose to represent themselves, but this is a serious decision with potential consequences and should be done with careful consideration. This is how they scare you up, all right, and make you think that it's next to impossible to go in there and stand before the court, not represent yourself, and definitely not allow them to call you the defendant. You are not the defendant, and you are not there to represent yourself before the court to be prosecuted. So this section right here, waiving the right to counsel. We're talking counsel, not attorney. And don't let the two terms get you confused and have you thinking that it's one and the same. An attorney can be counsel, but counsel is not always an attorney. All right. Counsel can be anyone who is knowledgeable in the law and who can assist you in understanding the proceedings. Okay, that is counsel. Waiving appearance at hearings. Defendant in some cases can waive their right to be present at routine status or motion hearings by filing a waiver form. In essence, waived for court signifies a conscious decision by a defendant to forego a specific legal step, often with the goal of either expediting the case or potentially gaining some other strategic advantage. So with that, it's another video done, another one down. And as always, Assalamu alaikum to the Muslims, Islam to the Moors, Shalom to the Hebrews, Hotep to the Egyptologists, Namaste to the Hindus, peace be upon you to the Christians, and good morning to those who are just waking up to this knowledge. Good morning. You're welcome.